Hey there. Today we're diving into the not so sunny side of Florida. And nope, it's not the humidity. We're talking about some common misconceptions about Florida probate that could leave you feeling a little lost at sea. As you might already know, probate is the legal process where a deceased person's assets are distributed. Sounds simple enough, right? But many folks think it's a terrifying legal process that costs thousands and thousands of dollars and takes years to complete. That's actually just the first myth. Lots of other people believe that every single estate in Florida has to go through probate, or that probate can be avoided totally simply by drafting a last will and testament. None of that is necessarily true. It is true that some assets can skip the whole rigmarole, like jointly owned property or things called payable on death accounts. But assets given away via the will alone may very well need to go through the probate administration process. All right, another myth. Probate is incredibly expensive. Sure, the costs can add up, but let's clear that up. Many people think they're going to need a gold-plated attorney and sign their life savings away. While there can be fees involved, think court costs and attorney fees, there are always ways to minimize these costs if planned properly. Some people save money by using Florida's small estate summary administration procedures, especially if the estate is under a certain value. A little research before you file goes a long way. If the estate is valued at less than $75,000, or if the person has been deceased for more than 2 years, summary administration could be the way to go. Now let's tackle another myth. Probate takes forever and is a total nightmare. Yes, it can be a lengthy process, especially if complications arise, but here's the thing. If an estate is straightforward, it can actually resolve in just a few months, with the right guidance, of course. So don't believe the horror stories you hear. It's not always a torturous wait time, very expensive, or endless paperwork. The next misconception that I hear all the time in my probate practice, your loved one has a will, so probate is not needed. Not true. A will does not help an estate avoid probate. It simply expresses the wishes of the decedent. Wills alone, without an accompanying trust or other estate planning instrument, must usually be administered through the formal court probate process. Lastly, many people who pass away without a will, when that happens, Florida statutes determine what happens next through our state's intestate succession laws. So there you have it. You're now sort of equipped with the knowledge to tackle the common misconceptions about Florida probate. Remember, knowledge is power, especially when it comes to navigating estate administration in Florida. If you have any questions at all, please feel free to reach out to us. We're here to help. We're happy to answer questions, and I would love to talk with you anytime you have a question. Thanks, and have a great day.